Hi, and welcome to the Law Simplified. I'm Shaveen Bandar-Nayaka. This is a practical guide to learning contract law. Contract law is a fascinating subject for a number of reasons. One of the primary reasons why I personally enjoy contract law and why I see most of my fast track and masterclass students enjoy the subject as well is because regardless of perhaps going into the profession by practicing or being a corporate lawyer, contract law is something that you will encounter on a day-to-day basis. Unlike most of the other subjects that you will encounter, contract law is quite insightful and it's quite fluid in a sense that we can apply it to our day-to-day lives. Now, having said that, we must approach the subject of contract law by looking at it as a life cycle. What I mean by that is when you take the essence or the topics that form contract law as a whole, you'd notice that they evolve over time of the contract. The fundamental categories that you would classify the different topics that you will encounter in this subject would be firstly the formation, the operation, and then the discharge or termination. This is why I consider it as a life cycle. You begin by establishing a contract in itself. You look at how exactly it operates and what obligations each parties have undertaken, how serious they are, and what sort of remedies are in place, and what even exclusions are in place if something doesn't take place according to plan. And then finally, what motivates the termination of a contract, so to speak. This life cycle then gets classified further into the different topics that we will encounter in this subject. For example, the formation of a contract is predominantly based on offer and acceptance, collectively considered as agreement, followed by consideration, what McKendrick considers as the badge of enforceability. These two together form what we call or what we know as a contractual arrangement. Once these terms are cemented and a contract is formed, the operation of it is undertaken by virtue of considering the types of obligations themselves that have been undertaken. These obligations can be classified as terms, and no two terms are created equal. What I mean by this is depending on how important a term or an obligation is to the functioning of a contract, we not only classify it as either a condition or a warranty, the former being the more important one than the latter, but it also specifies what remedies are available for an aggrieved party. So for instance, a condition, which is one of the most important types of a term or an obligation that goes to the heart of the functioning of a contract, a breach of which may lead to the opportunity for an aggrieved party to rescind or to cancel the contract, and also, depending on the circumstances, to even seek damages for redress, compensation, so to speak. However, a breach or an obligation which is in the category of a warranty not being fulfilled does not provide an aggrieved party with the chance to cancel or to rescind the contract, because it isn't as serious and it would be unfair on the other party to allow the aggrieved party to do so. Having said that, he still has the opportunity to seek damages or compensation for whatever loss or delay that he or she suffered. Every other topic that you will encounter in relation to contract law deals with, in one way, shape or form, either making a contract void ab initio, much like mistake, or voidable, such as misrepresentation. For instance, some actions may render the contract void at its inception, where the law considers that the contract itself cannot take place, whereas others might just give an opportunity to an aggrieved party to choose either to cancel, to affirm and proceed, such as misrepresentation, for instance. When it comes to situations that prevent the contract from taking place, not by the fault of any individual, rather by the circumstances that are out of the control of either party, such as frustration, this creates a situation where both parties are unable to proceed and therefore the contract terminates or comes to an end. Right, that was a quick overview of the practical aspects of contract law and what exactly you need to understand when studying this subject. If you'd like to learn more, make sure you reach out through the links in the description or have access to the comprehensive masterclasses on my online law school platform. But until the next time that we meet, have fun, stay safe, and as always, obey the law.